and welcome to the Priggya Arora Show, where we discuss law and entrepreneurship with people who have been there and done that. My name is Priggya Arora, an intellectual property lawyer from India, and our guest for today is Mr. Russ Krajec, who is the CEO of BlueIron IP, and I welcome him on the show. Welcome, Russ. How are you doing?
It's a beautiful day. I'm happy to be here. Thank you. Thanks for having me.
Thank you, Russ. And to begin with our warm-up question and something fun, who is your favorite fictional legal character?
Fictional legal character?
Yeah.
That's a pretty small universe.
Yes.
But I'll tell you one person who I really liked their story was Dennis Crouch. He's I've actually met him. He's an actual person. He's not fictional, but
yes.
He and I started blogging about the same time. It was probably early 2000s, back when blogs were weird and nobody was doing it. And his story, he doesn't tell it very often, but he was a lowly associate at this big law firm, and they gave him the unenviable task of writing summaries for all the court opinions for the Court of Appeals for Federal Circuit. So his job was to grind out these little snippets of the court opinion, send it to all the partners. And, it was a thankless job. But he said, oh, can I just post this on the internet and do it in a blog format? And he was able, and so they let him do it as a second year associate. And within a year, he had been on the front page of the Wall Street Journal twice.
Wow.
Because he was the de facto voice of intellectual property.
Yes.
And, that opened up a bunch of doors for him, and, and his career took off because of it. But it kind of speaks to that notion of do the thankless job. And, if you do a good job of it and some doors will open, which,
wow.
he was very successful with that.
Yeah, I think every intellectual property lawyer is familiar with his blog, and I didn't know the story behind it. As you said, sometimes a thankless job can turn out to be a big business.
Oh yeah, yeah. It opened a lot of doors for him, and when you look at, you can't name any other partners of his firm.
Yes, absolutely.
Except for him, at least from that original law firm that he was in. He's, now he's a professor at Mizzou and Columbia at the law school. So he's done very well for himself because of it.
Amazing. So Russ, now coming back to you, can you tell us your life story and how did you came up with BlueIron IP?
My life story is not nearly as interesting as Dennis's, I'll tell you. I was an engineer for a bunch of years, probably 13 years or so. And I'd been through the patent process a couple of times as an inventor, an inventor in a corporate environment, which means I submitted my invention disclosure form, and then some patent attorney called me. I talked to them, we signed some papers, and, a patent came of it. And I got my $100 bonus, which was the coolest part. And I had an invention outside of work that I wanted to bring to market. And I went to a patent attorney who was on my hockey team, and he gave me terrible business advice. He gave me no business advice. In fact, he just said, well, you could do this. You could do a provisional application. You could do a non-provisional. You could do a search. You could do this. You could do that. I'm like, well, what do I want to do? You've been down this road before. Help me out. And he's, well, I'll do whatever you want me to do. And he just would not give me the advice I needed. And so I was so furious with that I took the patent bar, became a patent agent, and then I wound up working for that same guy for about 3 years to learn how the business worked. And I was sensing the conflict of interest that, the patent attorney was just trying to sell hours, trying to sell a product to me. And the less I knew about the product, the less informed I was, the less he was going to help me, and it's a business about grinding out hours and, taking advantage of well, I shouldn't say that, but, I think in a lot of cases, patent attorneys do take advantage of their clients and take advantage of their ignorance.
Yes.
And they, inventors, be it small companies, be it independent inventors, think, oh, well, I have a patent attorney, therefore I'm protected. And they don't realize that you're asking the barber if you need a haircut, and you're going to get one every single time. And so this inherent conflict of interest between the attorney and the client, the attorneys recognize it. They understand the liability that they have. So that's why, and this is what I learned in the law firm, you never give advice to the client, because if you do, you're liable. If you come to me with some perpetual motion machine invention and I tell you, I don't think you should get a patent.
Yeah.
Even though it goes against my interest, because I need, I get paid when I do the patent. If I tell you, no, don't get a patent on that perpetual motion machine, but somebody down the street does, and they make, millions of dollars, you sue me, but you don't sue me for just the cost of the patent. You sue me for all your lost profits in every country of the world for the next 20 years. So my advice as a patent attorney comes with astronomically severe liability.
Yeah.
And the clients don't realize that liability, but the attorneys do.
Yes.
And so there's these two factors. One is the huge liability. The second factor is just, the asking the barber if you need a haircut kind of thing. The patent attorney wants to write the patent. They don't care. They don't take any risk in the patent. They get paid up front. And the perverse incentive of a patent attorney is that the worse job you do writing the patent, the more you get paid to fix it with the back and forth with the examiner. Yeah. So there's so many factors that I think hamstring the patent profession. Yes. That I created this thing called BlueIron. And in BlueIron, we don't represent clients. We finance patents. And if I finance your patent, I essentially do it on a leaseback model, but you can walk away from the deal and leave me with the patent. So my risk is that you stick me with the patent and I have to go sell it or license it or whatever. So I have this incentive to do a good job with a patent. Yeah. And I don't get paid up front. I get paid after the patent issues. So I got skin in the game. I got money on the table saying that I can do a good job creating the asset, and I'm willing to take the risk. And so with BlueIron, I try to turn the tables to say, I'll put money on the table that I will guarantee I'll do a good job. And if you don't like it, walk away from it and I'll take the patent.
Awesome. So awesome, Russ. I know, starting this business have been a little difficult because of so many risks involved in it. So do you analyze the technologies first and then put your efforts into it, or how is the process? Like, can you tell us something about the process? Say, for example, if I am an inventor and I come to you with some clean energy technology, what would you ask me to do?
Okay, patents have value
Yeah,
when product is in the market.
correct.
Okay, so how do I, if I'm investing in this company by financing their patent, I want to see revenue. I
Yes.
want to see a track to get to revenue. I don't want to, an idea is absolutely worthless until it gets into the market. And a lot of people say, oh, well, I got some idea for some multi-trillion-dollar clean energy nonsense. Well, great. That's absolutely worthless. If you had an installed base of 10 billion, $10 billion worth of product out there that are producing this green energy, yes, we have a good business, we have value.
Yeah.
But there's a mistake between actual value and potential value.
Correct.
You look at it and say, oh, I have some green energy nonsense that, oh, wouldn't it be great if everybody had this at their house and was creating energy? Yeah, that'd be great, but it's not reality. And if I look at the potential, it could be $1 trillion, but what's the reality? The reality is zero. And so when if I'm going to invest in a patent, I'm looking at, does the entrepreneur have the right financial backing to bring the product to market? Do they have the right skill set? Do they have the right connections in their Rolodex? Do they have have they proven the technology somehow, prototyping? Do they have the marketing savvy to bring this thing to market? Have they proven that with some kind of market acceptance? If they've done that and they look like they're going to be successful or have a high chance for success, then I'll finance the patents, and I'll build out a bigger portfolio than they can normally afford. I'll build out a better portfolio than they can normally afford. And I'll insure the patents so they have the ability to enforce the patents. And then on top of that, if they hit some revenue targets, we could loan $5, $10, $50 million to the company using their IP as collateral.
Yes. So
it changes the whole conversation from, oh, I just want a patent because I'm afraid somebody's going to steal my idea, which is kind of the worst reason to get a patent. It changes that conversation into, we're creating assets. We're going to monetize we're going to put those assets to use. We're going to protect those assets so that we can use them for enforcement, for licensing, for cross-licensing, for standard essential patents, for whatever. And that's kind of what BlueIron is all about.
Wonderful. Your business, the approach you have towards business just blows my mind, that I want to learn that how this industry works and everything. So another question that I want to ask is, patent process in itself is a kind of a longer process. Like in India, we generally take 3 to 5 years to get a grant. I think in US, we have a time period of from about 1 to 3 years. No. So,
okay.
So when is the actual, what is the life cycle and what is the timeline when the revenue starts coming up from a technology? Well,
first off, patents do not have to take that long.
Yeah.
There's this thing called patent prosecution highway, which is, I don't know if India has it or not, but there's some agreements between multiple countries where each country will accept the or would recognize the examination done in a different country.
Correct.
And when you have allowable subject matter in a foreign country, in a different country or in a different situation, you get in the US special status, which means a 14-day turn on every office action.
Yeah.
And so, and you can get this first examination in multiple ways. One way is to get a PCT application and get the examination quickly. And if there's allowable subject matter, then you're able to use this thing called patent prosecution highway in the US. It's also available, I think, in Europe and in Japan, and there may be other countries as well that participate. And so the way to get patents reliably and quickly is to file them somewhere.
Yeah.
It might be PCT. Singapore is exceptionally fast.
Yes.
You can expedite in Australia, or you can expedite in Canada, for example, pretty quickly, and get allowable subject matter, then come back to the US and get special status and get a quick examination. The benefit of this is a couple things. One is 2 different examiners look at the claims.
Yes.
So you have pretty good assurance that what's going to be allowed is pretty tight. You can contrast it with the USPTO has this thing called Track 1, which in my view is I shouldn't say complete disaster, but it's a disaster. It skips all that, goes to special status right away, and the examiners are encouraged to they're financially incented to do a very quick examination and get the thing either allowed very, very quickly, or they kick you out of the program as fast as they can and get you to final status.
Yeah.
And so their incentive is not to do a good job, it's to do a fast job.
Yeah.
And here's the thing, is that Track 1 cost about the same as a PCT application.
Yes.
And so you could do a PCT with the double examination and get a PCT application for international filing at the same cost as Track 1. And by doing that, you get a better application, you get it allowed faster than Track 1, and you with PPH, you keep your special status through appeal. So there's no way the examiner can kick you out of the program.
Awesome.
And so we can, when the business needs it, we could get patents typically 6 to 9 months on PPH.
Yes.
Which means we could finance the patents today. We could hustle the patents. PPH takes a little bit more work on the patent attorney, which is why lazy patent attorneys do Track 1 instead of PPH, because it's just less work.
Yes.
But once we get, if the business needs it, we could finance the patents. We can get the patents issued relatively quickly, and within a year, if they're hitting the revenue targets, we could loan against those assets.
Yeah.
And the beauty of this is that we can do a Series A, Series B, Series C level financing purely on assets that we'll finance the creation of them. Yes. We'll finance the creation of the asset, and then we'll loan against it. And so you don't get diluted with another round of investment and so on.
Great, absolutely. So just to give you an idea about India, we currently have PPH only with Japan and not with US or any other country, but we foresee PPH with other countries very soon, so that we can also, take some approaches of faster patent prosecution. Let's see how time comes up for
Well,
us.
I'll get, it's a, it, the, to me, the best part is two examiners look at it.
Yeah.
So we have, a much higher confidence in that asset.
Yes.
And the incentive is not to just get it done fast, it's to get it done well. And so I really like the PPH process, and I'm surprised how few people know about it and how few people actually use it.
Yeah, definitely. So Russ, now you have been financing various kind of technologies and IP. What, according to you, is the most favorable technology area?
The anything where we have decent consumer or customer, doesn't have to be the end user consumer, it could be B2B, but anything where we have good customer feedback and good customer engagement.
Yeah.
It's really about investing in a business that has a good chance of success, and not just an idea. Ideas are worthless, but if you have somebody who has that talent stack of bringing a product to market, of recognizing, how to communicate the value of the product, and they have the ability to go out there and sell the product, it's probably going to do pretty well. And the question is, can we get patents to help protect their investment in their marketing? And maybe we can, maybe we can't. But if we can, it's a good synergy.
Yeah, it is just like, a typical investor. He says that I don't invest in company, I invest in the person or the founder of the company.
Well, I think that's kind of trite, but there's the ideas, the ideas are just 1% of the product,
Yes,
1% of the work. The rest is execution. Correct. And if you have a good idea with no execution, it's still worthless. So you want to invest in the people who are likely to grind it out and be successful.
Perfect. Yeah. So another question, I know it's a dicey space. So do you see a more or less, or what is the number of patents regarding computer technologies in financing? Because it's a tricky space as far as USPTO and other patent offices are concerned.
There's a bunch of misinformation about software patents and patentable subject matter and that kind of stuff. Once I, to kind of talk about my story a little bit, back in the day when I worked for this patent attorney for about 3 years, then I went to law school, then I opened up my shop as a patent agent while I was still in law school. And there I was able to do a lot of patents for Microsoft, probably 300-400 of them. So I've done a large amount of software patents. Most software patents are worthless, but not because they're software patents. The fact that they're software patents really doesn't matter. It's a machine that does something, no different than Eli Whitney and the cotton gin. It does something. Most software patents are worthless because they're undetectable. Like if I have some machine learning, AI, blockchain nonsense that happens on a server somewhere, will I ever have access to source code to find out that they're using my, machine learning algorithm? The answer is no, I never will. And so the net effect of the patent is that we took the most precious secrets of the company and we gave them away to the world And in return, we got patent claims that are undetectable, meaning they're unenforceable.
Yes.
And so I see a lot of people running out to get patents on algorithms, and patent office will grant those all day long.
Yeah.
And patent attorneys are more than happy to take the money to get these, but they destroy the company. Well, at my angel group, we looked at a company that had a cybersecurity product that was a software patent. And one of the angel investors at a previous angel group had told them, well, that's really interesting IP. You should get a patent. And the inventor was, no, I don't think we should. Oh, no, you should get a patent, the angel investor said. So he went out and got a patent. And thankfully, by the time I was doing the due diligence, the patent had never been published. But if that patent had been published, it would have laid out for all the hackers, this is exactly how we track you. This is exactly what we look for and how we respond if we see that you're hacking us. And so that patent would have completely decimated the value of the company. And it was purely done because an investor, a so-called angel investor, kind of strong-armed the entrepreneur into getting a patent. And thankfully, what we were able to do is abandon the patent, do an express abandonment, and make sure that that patent is forever secret and never sees the light of day. And the patent attorney wrote the patent. There was a patent attorney who wrote the patent and took that entrepreneur's money and wrote a patent that would have decimated the company. And it's shameful that the patent attorney even took that money. And it's shameful that the patent attorney even, should have had the confidence to tell them this is a bad idea. But sadly, that doesn't happen. And that is really what the problem is with software patents, more so than the whole patentable subject matter nonsense that's, going on.
Absolutely. You have explained it beautifully well, and I know it is a sad situation where few attorneys, they do not tell the inventors that it's harmful to actually file a patent on a software when it can be protected.
It's not harmful to get patents on software. It's harmful to get patents that are undetectable.
Correct.
It's harmful to get patents that hurt the company. And it doesn't have to be software that harms the company. A chemical formulation, a method of manufacturing is a classic example.
Yeah.
Oh, I got this great method of manufacturing. I could produce widgets 10 times faster than everybody else. Well, that's something that should be in a factory behind closed doors. It's never something that should be in a patent. Yet patent attorneys take the money, harm their clients, and get method of manufacturing patents for their clients. And think about, the methods are infringed when and where they're produced. So in the US, if I find out that my competitor is using my method of manufacturing and I sue them, what could they do? Well, they could pack up their machines and move to Mexico or Canada or India or Zimbabwe or wherever, and they can make that product without infringing. Think about, a lot of software patents are bad because of this, the benefit of cloud computing. If I have a software product that works in the cloud and I sue a competitor, what can they do to get around it? They could take one limitation of my claim and put it on a server, and with one click of a button, they can move that server to Europe or Canada or Vietnam or wherever. And so the infringement never occurs within the jurisdiction because of cloud computing. And so there's a lot of stuff that the technology is sophisticated enough and, and it works. It doesn't work well with the patent, or the patent system doesn't work well with that. Where, if I had a patent in all these countries, maybe I could enforce that kind of distributed infringement.
Yeah,
But so there's things that the patent system just doesn't cover, and
absolutely.
yet patent attorneys still take the money. That's the shameful part.
Yeah.
Patent attorneys aren't, they have a financial interest in getting paid today to write that patent.
I know. And Russ, sometimes what happens is, even if we are telling the inventors don't file the patent for this. I think there have been instances that I have pleaded the inventors don't file because, as you said, the IoT patents have this problem of the server can be shifted anywhere in the world to
And the
go.
inventors still say,
Yeah.
but I want one anyway.
But I want a patent. I want a patent. I want a patent.
You can withdraw from representation.
Correct.
You don't have to take their money. You can withdraw from that. You can say, you know what, I don't think that this is your best interest, and for your benefit, I'm going to withdraw. You could go down the street to another less ethical
Yeah.
attorney, but you always have that option. You're not required to do it.
Happens with me all the time, especially when people, they do not understand that why we are telling them not to file an application. So yeah. So now
But you're stuck in that.
Yes.
In that situation, the client really, really, really wants the patent. And for a lot of clients, getting a patent, for a lot of inventors, getting a patent is a very, it's a badge of honor. It's a
Correct.
huge accomplishment. And it's an accomplishment that's so important to them that they would be willing to risk the fate of their company.
Correct.
To get that patent. And and but the thing is, nobody's talking about this.
Yeah.
And so, patent attorneys and even the patent offices themselves make it out to be a really huge accomplishment, which it is. But at the same time, it comes with a trade-off that nobody's, hurts the patent bar. If we tell people don't get patents, we're cutting our own throat, right? So that's why that's the conflict of interest that nobody wants to talk about.
Correct, absolutely. And nobody talks about this. I agree with you 100%.
Why should they? We're making money. And the best thing is if we can get somebody who has some machine learning, blockchain, distributed, whatever kind of invention, that thing's never going to get enforced.
Yes.
And so, nobody will ever find out that I did a terrible job writing that patent application because it's never going to see the light of day. And so, and people start charging a premium for software patents because they're software patents, and the market will bear a higher price. The truth is the software patents are far easier to do than what's a quote simple mechanical invention. Those are brutally hard. But whatever, the market will bear more for software patents.
I don't think I agree with this one because software is a tricky part, especially when a lot of jurisdictions are involved. So we have to, do our checks and balances. And whenever I think attorneys are stuck with the inventors, like they want to file a patent, it becomes absolutely necessary to, determine what part of an invention can go into the application and what part of it should be kept as a trade secret. So I think one important area, and it takes a lot of analysis to determine that we have to give a very small part of an invention in the patent application, and rest of it we have to suggest that it should go in a trade secret. So there the job, it kind of takes more time.
Well, the part of that, it also depends on what's the business model of the client. Absolutely. If the client is providing this, software as a service, then a lot of the stuff that happens in the cloud is probably should be a trade secret.
Correct.
If the client is thinking about licensing their IP to other people who are going to build the product, then you might want to consider getting patents around the stuff that happens in the cloud.
Yeah.
And it really depends on their business model. And the unfortunate thing is the business model changes.
Yes.
At first they think, oh, I'm going to go to market with a software as a service product. And then, and then they might want to switch to a licensing model later, but the patents were created for a software as a service model may not be exactly what you wanted later when you figure out that you want to do a licensing model. And, it's not, there's no simple solution. And, you're highlighting a lot of the problems that, well, it's not a problem. It's just a thing that we have to navigate as we build out, make the right decisions with the information that we have at the time for how best to get patents or IP protection.
Yes. So Russ, now this podcast is about you and legal entrepreneurship. So let me ask you some questions about you. So what keeps you motivated and how do you work? Like what are a few elements that keep you motivated?
For me, the thing that really motivates me is to learn something new or add a new skill set. I like being able to master something new and explore something new, whether it be, how best to create a website or online marketing for the ideas, how best to communicate, some of these concepts that we're talking about. What's the best way to find those clients that will be, where this would resonate with them.
Yes.
That's a different challenge than the challenge of how do I craft a good argument for a patent examiner? And each one of those skills is a different skill. And to me, the fun part is adding another layer to that skill stack and being able to experiment with them. Once I get, I with every skill, you kind of reach a level of competence and you feel comfortable, you kind of conquer it for a little bit. And, once I conquer something, I kind of feel bored with it. And then I move on to something else. And then oftentimes I go back to that skill that I thought I conquered and figure out they got a lot more to learn with it. And so you are constantly kind of moving forward with that. That's probably the best thing for, the thing that makes me excited and makes me roll out of bed and, shuffle down to my, the good thing about working from home is I wake up in the morning, I'm still at work. Right. So grinding away on the next project.
Awesome. It's so interesting to meet like-minded people who believe in learning, who want to, stay excited. So for me also, it's like random skills. I'll learn random skills and I'll be like, let's see how it goes. So now Russ, coming to our 3-1 rapid fire round very quickly. 3 things you are grateful for.
3 things I'm grateful for. Certainly I'm grateful for my health and my family and I'm very thankful that I live in a land and a time where there's so much opportunity. Being able to pick up try a new business idea it's never been easier than it is now, and it will constantly keep getting easier. And so I wouldn't change that for the world.
Yeah, time and technology, land. With land, it makes it appropriate for us to start new business from anywhere in the world.
Oh yeah. I mean, I got a client who sells product on Amazon,
Yeah.
and he can order stuff off of Alibaba, have it shipped directly to Amazon, who does fulfillment. And, they handle shipment and returns, and he doesn't even have to touch the product. I mean, and you can do that with very little capital. And so the opportunity the opportunity cost for missing out on some of that is actually pretty high. I mean, you can get a lot of businesses going that 20 years ago, we just didn't have that. It would have been a lot more capital intensive.
I'm sure people who listen to this podcast will try this idea very soon.
Oh, sure. Why not?
Yes.
My 80-year-old mother sells stuff on Amazon.
Wow.
Okay. So it's open to everybody.
Awesome. And now 2 traits you think are important and useful for someone in the same field.
2 things that are important.
Traits, habits or traits.
Oh, habits or traits. The biggest trait is learning from mistakes, and kind of the corollary to that is not be afraid of mistakes. If I write a patent application and the examiner allows it, did I do a good job? I don't know, right? It's when the examiner comes back and says, what about this? What about that? Or, here's some prior art. How do you differentiate over it or whatever? That's when I figure out if I did a good job writing the patent. I'm not looking at the part that was successful. I'm looking at the part that had the problem. And if I can look at that, the next patent I write is going to be better.
Yes.
And that, that happens all through life. If something went well, you don't learn nearly as much as if something went badly.
So don't be afraid to make mistakes and learn from your mistakes.
Well, try to perturb the system and see where it breaks.
Correct.
Try to shake it up. Be intentional about making those mistakes so that you can learn from them.
Yes. And one aspiration you have for the future?
One aspiration? I'm very, very upbeat about the future. The opportunity that I've seen through my lifetime and the way society works, the way technologies advance, the way the economy is shown, an incredible resiliency. I think it bodes very well for the future. I don't know that you can or even should or even bother to point out what is going to be, the winners or the losers in the future. I think there's just a ton of opportunity here, and it's up to us to capitalize on it.
And Russ, to conclude, can you share some key takeaways for young lawyers and entrepreneurs?
The thing I encourage entrepreneurs to do is, and for young lawyers too, is think about their skill stack.
Yeah.
And you want to build as many skills as you can if you're learning. When I took the patent bar and started working at a small law firm, I wanted to learn everything. I wanted to know how they did accounting. I wanted to know how we, what do we use for case numbers and file numbers? how to organize the files together, file naming conventions, whatever. I wanted to have the skill of being able to file everything with the patent office myself. I wanted to have the skill of being able to read my own, proofread my own stuff. I saw other attorneys or patent agents in the group who couldn't do any of those things, and they were dependent on somebody else, a paralegal typically, to do all this work that they didn't feel comfortable doing. And so I wanted to learn how to do every single bit of it. And it's not that I needed to do all that stuff or that I was efficient at it, or in the future I might not, I might hire somebody to do that for me, but I needed to have that skill set. And as far as entrepreneurs, they should be thinking about the business that they're going in terms of how they can build on their skill stack. If they're not very good at marketing or whatever, take this opportunity to learn more about it and get better at it. If they're not good at manufacturing, take this opportunity to get better at it. With entrepreneurs, if they're any good, they're not going to have just one idea. They're going to have endless ideas.
Definitely.
And so if they can just use this time through the system to learn more about, to add some skills, they're going to be much better prepared for the next idea.
Awesome.
And so, there's no end to the journey. It's a journey. And our job as humans, our job as entrepreneurs, our job as lawyers are to travel that journey with the best, with everything we have.
Yes.
And be intentional about learning those skills. Be intentional about, I'm going to go into this opportunity because I'm going to learn something new. And choose that opportunity because it presents an opportunity to learn.
Awesome. Just to reiterate, build your skill set, choose your opportunities, and enjoy your journey. So thank you, Russ, for being on the show and sharing all the insights. I'm sure our audience is going to love it.
And I enjoyed it thoroughly. Thanks for having me.
Thank you. Hey there. Thank you for attending today's session. If you enjoyed today's session, do follow our channel and consider sharing it with a friend. My name is Priggya Arora, daughter of inspiring parents, alumna of IIT Kharagpur, engineer turned lawyer and entrepreneur, and now founder of PA Legal, where we help creators and innovators protect their intellectual property. Thank you.